Right now we have 27 questions. Okay, our first question is, let's see, barring any legislative rules to the contrary and no restrictions in the community documents, can an HOA, Condominium Associations Board, approve and declare and impose a secret ballot, i.e. restrict members from determining how other members voted for any community-wide vote, such as an election or a special assessment? Okay, so let's talk a little bit about secret ballots. So you are required to have a secret ballot if your documents require you to have it. Okay, so typically we see it in the bylaws. Usually it's in the annual meeting section where they talk about directors are elected by a secret ballot. Sometimes it refers to other things as well, like any vote taken by the board, by the association, a secret ballot. So what do you do? I'm not quite sure in this situation is, so it looks like obviously in Arizona, there's no requirement to have a secret ballot. Okay, so you should know that up front. In your association, you're saying that the documents also do not require secret ballot. So there's kind of two ways to cut this. So maybe your board is thinking about using a secret ballot. They have a choice to do that as a board when they're, voting on something. In my experience, over a quarter of a century experience, most boards would not voluntarily, most meaning 99% of boards, would not voluntarily choose to make a ballot a secret ballot. Okay, the only ones that are doing it are required by their documents to do it. So that's important to note. Why do they not want to do it? Because it's a huge hassle. There's a couple reasons why it's a hassle. Number one, to put the ballot together, it's more complicated. You have to have a double envelope system so that the ballot is in an envelope that doesn't have any identifier on it to identify who's voting it. And then the second ballot has the identifiers on it, and they're separated at the time, that the ballots are opened. So there's a cost to doing it, and it's harder to do it that way. The other reason why people don't like doing it as board members, having it for your community, is because people get the ballot and it's difficult, right? People don't know. They think that the ballot had a mistake. Why isn't there a place for me to sign? Why isn't my unit number on here? And lots of times people don't fill it out right, and they put the identifier on it, which could potentially invalidate the ballot. So, short answer on this would be that most associations are not choosing voluntarily to do a secret ballot. They're only doing it if they have to. The other side of this is, okay, let's say that you had a ballot that wasn't a secret ballot, and, the board doesn't want to share who voted how on the ballots. There's really no way around that. If the ballot is a record of the association and you have the records, you have to provide those records to an owner if they ask to see them. So, that's just how it works. So I hope that answers your question. Most boards are not using secret ballots unless their documents require them to do it. And if somebody wants to see how ballots were voted and they weren't secret ballots, the board has to provide that information after a written request for a records review of those ballots. Question 2, to what extent, if any, are proper minutes for an association meeting different from those of a board meeting? For example, are association minutes approved by the board or by a vote of the members? As with board meetings, are association meeting minutes limited to member actions and votes, not what members or guest speakers say? Okay, so there's a good distinction on this. So this question is asking me to, make a distinction between regular board meeting minutes and meeting of the membership meeting minutes. So example, like the annual meeting minutes or a special meeting of the membership to vote to remove a director, or a special meeting of the membership to vote to levy a special assessment. So we're looking in this question is, how are they different? So regular meeting minutes are, reviewed at the very next board meeting. So for example, let's say our December 2023 regular board meeting, we took minutes, and then at the January 2024 board meeting, we review those minutes as a board and approve them right then and there. Okay, so you do it right after the meeting, month after, typically if you have monthly meetings, or if it's quarterly meetings, at the quarter after. The board reviews and approves. Membership meetings are a little bit different. So like your annual meeting or like your removal meetings of a board, etc., those are approved at the next regular meeting or the next meeting of the membership. So for example, if you had your annual meeting in December 2023, you will not have the membership approve the annual meeting minutes until December of 2024 at your next annual meeting. So you wait a whole year to approve them. That's it's unusual, and I get a lot of pushback often from people like, that doesn't make sense. That's a whole year. Well, it does make sense in that the only people that can approve those meetings minutes are the members, because it's a members meeting. So you wait until the next members meeting. Same thing, like let's say in between the annual meeting, you have a removal meeting of the board, right? And at the next annual meeting, you should also approve those meeting minutes, because that's your next meeting of the membership. How are they different? I recommend that you take a look at our cheat sheet on board meetings, how to run an efficient board meeting, I think it's called, a perfectly proper board meeting. On the flip side of that, we have how to take perfectly proper meeting minutes. The meeting minutes are the same for annual meetings, meetings of membership, or board meetings. Basically, keep them short, and it really should be what was decided. Was there a quorum? Who attended? What was decided by the board at a board meeting, or what was decided by the community members? You can put a short sentence like there was a treasurer's report, and explain the finances of the association. That's fine, but you don't have to go into detail on it. If you want to make an attachment like the financial statement or the budget, you can attach that to the meeting minutes. That's fine. And so I think that pretty much answers it. So how are they different? I explained that. You don't really want to go into in either set of minutes a long diatribe about what somebody said. It's what happened at the meeting is the most important thing. Okay, next question. What happened, meaning what vote was taken and decided at that meeting, whether the vote failed or whether the vote passed. Okay, next question, number 3. Are HOA CC&Rs prohibit RV parking anywhere in the association except when loading or unloading from a trip? But the CC&Rs do not define RV. This has led to arguments from a couple of members that their RVs are not RVs, but are cargo vans or even storage vehicles. The board is planning to write an amendment to the CC&Rs prohibiting parking on the lot of any vehicle larger than a specified size. Vehicles other than RVs would now fall within the restriction, including larger trucks. Existing owners of such vehicles would be grandfathered in. Trailers and boats are already prohibited from being parked on member properties and will still be prohibited in the new amendment. Is this a workable solution? So you want to write an amendment to the CC&Rs being more specific about, defining RVs. I think that would be fine. It looks like you want to expand it to some other larger vehicles too. Just remember that, you're going to want to get advice on the language for the amendment. And we're also going to want to look at the amendment and as to whether or not this is foreseeable and reasonable under the Callaway case. So I would suggest you reach out to our firm, but based upon what you told me here, everything looks like it's, you're moving in the right direction, and I'm not opposed to it. Okay, number 4. How likely do you think HB 2270 will pass? I'm specifically interested in the requirement to supply a meeting agenda with the announcement of a board meeting. So this is a new bill that has been introduced in the 2024 legislature, and it covers a lot of topics, or wide range of topics, ranging from the open meeting exceptions to remote meeting technology and posting notice for meetings. You're talking about page 7 of the bill, which states, it says at least 48 hours before the meeting and may be revised as required by the board president or committee chairperson to add or remove agenda items based upon the developments since the draft was issued. If the meeting agenda includes proposed approval of an annual budget or a policy or rule, that proposed budget, policy, or rule shall be posted along with the notice of the meeting. How do I think it's going to pass? I never know at this stage, right? So really, we have already been advising associations that they should be including an agenda with their meeting notice. We've been advising them to do that for a couple of years already, because there was legislation a couple of years ago that talked about if you're doing a bylaw change or a rule change, that you needed to indicate that you were doing that in the notice. I'm not opposed to having the agenda, state with particularity what that rule change would be if, this law would pass. So I am not opposed to it. I think it's good. We want to be transparent. We want people to know what's going on in the community. Is it kind of a hassle to do this? Yes, because sometimes things change, within 2 hours before the meeting. Sometimes the agenda is changing. How likely do I think it will pass? Sometimes with legislation, you have to see it introduced a couple of times before it actually gets legs and gets passed. So, I think it's, I don't think this particular part of it is likely to get passed, although it could be considered like an extension of the bill that was a couple of years ago. It just further defines it. So maybe it is something, we'll have to wait and see. But I'm not opposed to it if it does pass. I think it's probably something that would be helpful to the owners. Okay, next question, number 5. And I want to say thank you to my team because, all these new bills were just introduced in the past week. And for them to get that into to get the exact language for me and to help me answer this question, I really appreciate my team. Good job, team. So thank you for doing that. Okay, number 5, what liability would a board or homeowner have if volunteers who are not licensed, bonded, or insured do work, such as electrical repairs, cutting down trees, if that volunteer becomes injured, or if there is something that happens to someone else because of the work that they have offered? What liability do we have? We have a great blog that we've put out there on Be Wise when it comes to volunteers. And so I want to encourage you to take a look at that. We're going to be sharing that with you on Zoom and Facebook Live. Also, you can find it on our webpage at mulcahylawfirm.com under our blog tab on our homepage of our webpage. Okay, so there's a lot of liability, actually. So, it depends on what work the volunteer is doing, right? But electrical repairs, cutting down trees, that should never be happening by a volunteer, ever, okay? Those are tasks that you need to be bringing in licensed and bonded contractors to do the work. Sometimes if you're having, volunteers, something that maybe would be more acceptable would be like a community-wide trash pickup where, we spend a Saturday morning, and everybody looks for trash in the common areas and then we have coffee and donuts at the end. Or maybe changing, a light bulb that does not require you to get on a ladder. I've kind of done all those things as a director myself. Where you get into dangerous territory is where you have a volunteer doing tasks that are, really required to have somebody who's licensed and bonded, and then they get injured. Well, what could happen there? I mean, there's lots of things. We could be sued and have to pay their medical bills. They could be considered, under workers' compensation, even though we're not paying them. We may have to pay their medical bills. So I would very much encourage you not to do that on these type of tasks where, you need to have people who have some expertise and it's inherently dangerous. There's all kinds of liability here. What if they do electrical repairs and then ultimately it causes a fire or somebody gets electrocuted? There's liability for the association right there. If there's an accident, now we have liability for whatever harm is caused to the person. The board can be sued for breaching their fiduciary duty to the corporation and their duty of care and not hiring licensed and bonded contractors. So just be really careful on something like this. There's a lot of liability, and I am the first person to encourage boards not to have volunteers doing tasks like this. Okay, question number 6. I have hearing and visual problems, and I'm 79 years old. I have requested attending a board meeting by sitting within the boardroom in our clubhouse. I have been told no, it is only a Zoom meeting. Several have requested that the meetings be recorded so they could be listened to by those unable to attend or re-listen to for clarification. The board has absolutely refused to allow this to happen. What are your feelings on this? Okay, a couple things. Most boards now, truthfully, are having meetings by Zoom. That is just the norm. I very rarely do I now attend meetings in person. Most boards prefer to have me attend by Zoom, and most boards prefer to conduct their meetings by Zoom because owners prefer it, and they get a wider cast of people who can come. For people who are in Wisconsin or Michigan or Minnesota in the off season, they can still participate by attending by Zoom. Okay, but you have a special situation here where it sounds like you have you potentially have a disability under the Fair Housing Act, and you want to come to the meeting and sit with the board in your clubhouse because of your hearing and visual problems so that you can listen in person in the meeting. I'm assuming that your board is meeting in person, but then everybody else comes by Zoom. Okay, so I think under the law, under the Fair Housing Act, I think the board does have to make a reasonable accommodation for you if you can provide a letter from your doctor stating that you are, required to, be there in the clubhouse, and why. It has to be directly related to your disability. So one workaround would be is if they don't want to have you in the room with them for whatever reason, because COVID's going around again and there's a lot of illness right now in Arizona. There's different factors. They should try to make a reasonable accommodation some way to make it easier for you to hear what's happening at the board meeting. So, maybe we are required to provide a recording as a reasonable accommodation, meaning the board record the board meeting. Or maybe you should be allowed to record it. Under the law, just so you are required to, or you are allowed to record any board meeting. If a board has a policy regarding recording board meetings, you just have to follow that policy and notify them that you're recording it. So, I think that we need to have, the board needs to be aware of their requirements under the Fair Housing Act. And I don't know if your hearing and visual problems are, considered a disability on the Fair Housing Act. I'm assuming they probably are. And if you get a letter from your doctor, they're going to have to make a reasonable accommodation for you. Okay, next question from one of my favorite former board members who's a homeowner in an association. Great to see you here today. Our HOA organization recently hired a new management firm. Numerous written requests for minutes have been ignored. What are some suggestions for resolving the problem? Okay, so you've made written records requests to the board for records. I heard you have a new management company, so I'm sorry that this is happening to you. This obviously should not be happening. You're asking for regular meeting minutes. I'm assuming you know that you're not entitled to executive session meeting minutes as a homeowner. What I would do is just send one final letter stating that I know that there's been some changes recently at the association. You may have missed my records request. Send it directly to the board and to the new management company and say, I'm sending you this, final reminder that you have 10 business days to provide me with the following records, and then list what exactly you want to see. If you don't comply with sending me these records by X date, I plan to, and then you have a number of options. So you can hire a lawyer to help you get the records. You can go to the Arizona Department of Real Estate and for $500 file a complaint against your association, and then an administrative law judge will conduct a hearing as to why you're not getting the records. That probably will be a quick way to get their attention. You can file a lawsuit to get the records. If it's important enough to you, to the expense to do that, you can file a lawsuit. You can pick up the phone and call the board member if you know anybody on the board and say, hey, I don't understand why my requests aren't being responded to. So those are all the different options that you have, in this situation. Maybe they have them on their website. I don't know. Maybe check to see that they're not readily available somewhere online that you can look at them. Okay, question number 8. Is there a hierarchy for all the state and federal laws for HOAs? Really good question. So I wish I could say yes, and there was some really easy rule, but there isn't. So, I mean, typically the federal laws, they're not conflicting with the state laws. I can't think of really any examples on this. Maybe like, okay, so the satellite dish laws that went into effect in 1996, allowing owners to have, a 39-inch or less satellite dish on their property, which is kind of outdated now. No one's really using those anymore. That trumped anything in your documents that said no satellite dishes, right? So that federal law would trump your association's documents. But they're really the federal laws that are on our radar now are the Corporate Transparency Act, the OTARD rule, which deals with satellite dishes and antennas, the Fair Housing Act. If you're an association as a place of public accommodation, like a public restaurant, the Americans with Disabilities Act. There aren't really that many federal laws that are out there that apply to us as an association. Now, state laws, those, it just depends on how the state law is written. So sometimes it says in the state law that, unless provided otherwise in your document, do this. If it says that, that means your document controls. If it says notwithstanding anything in your documents, that means state law controls. So you kind of have to look at every single statute to see if it trumps your documents or not. So I wish I could give you a bright line rule. I can't, but if you ask a specific question like, does this state law trump what our documents say? I can tell you specifically whether it does or not. Okay, question number 9. If the board doesn't respond or if the community is successful in removing an entire board, what happens next? Okay, great question. So you're talking about the new law that went into effect on October 30th, 2023 about board removal. So let's say the board doesn't respond to the removal petition within the 30 days. Basically, what happens is the law says that the board is automatically removed. So what is the next step? And it's the same next step if the board the homeowners have a meeting and the entire board is removed from office, right? It's the same next step. We have to send out a communication to the membership. Usually the attorney and the management company, if you have one, will assist with this. So there's no board in place in this situation. And we have to solicit volunteers to be on the board. We have to send out a notice of meeting, and we have to actually conduct a meeting to elect new board members. And so, hopefully that answers your question. Number 10, HR 2084 proposes to strike 33-1804, the ability to give notice of meetings via pamphleting via delivery to each unit, and requires the person notice or delivery to registered email or address. In case of lethargic or uncooperative boards and management, wouldn't this change inhibit the members' right to call a meeting to conduct business, including recalling a board, as members do not have access to the registered contact info and rental units do not allow for ease of in-person contact to assure notice of 100% of members as required? Okay, this is kind of a confusing question for me. So let's see. Not sure exactly what you're asking. So you're asking about HR 2084, right? And I'd have to actually look at the same statute at the same time. So let's move that to the end of the presentation, and maybe somebody on my team can pull that up for me and I can look at this. Okay, question number 11. Is there a differentiation between snowbirds and year-round residents for short-term rental amendments? Really there shouldn't be. I guess this is a tough question for me to answer because I'm not really sure what you're asking. So snowbirds are traditionally kind of defined as maybe November to April. So I'm wondering if you're saying like, is there a special exception carved out for snowbirds because it's like maybe 5 months and versus year-round residents for short-term rental amendments? Maybe you're saying that snowbirds own and can they short-term their property when they're not there? I'm really not sure what you mean by this question. I'm sorry. I wish I understood it better. I think probably the bright line rule on short-term rental amendments is they're uniform. They apply to every unit or lot in the same way. And so, they're there shouldn't be a differentiation. If you have a short-term rental amendment in your documents, your board needs to follow it. Okay, question number 12. Can an HOA board of directors make changes on the community bylaw, such as board of director terms limit, without a vote from the homeowners? So it really depends on what the amendment section in your bylaws says. If the amendment section says that the board has the right to amend the bylaws, then yes, they can. Again, we got to go back to the notice requirement. So the notice of the meeting, the current law says that if you're doing an amendment to the bylaws, you just need to notify the membership in the notice that you're doing an amendment to the bylaws, so that if members want to attend, they can attend that meeting. Okay, number 13, our HOA clubhouse is being used weekly for a poker game that has a $20 buy-in. Not all the players live in our HOA. Does gambling create a liability issue for the HOA? I've seen this issue come up, and same thing with bingo, like there's a buy-in for the card on bingo or whatever. I'm not a gaming expert by any means. You may want to contact the state of Arizona, anonymously to see, is there an issue with this? I am not sure it is an issue because it's, I'm assuming that there's a resident inviting people to come in. It's not like some, 100-person game or something like that where you are doing that. It's probably just, a small group. And I'm guessing that all the money, gets distributed at the end, the winner. So I don't really know the answer on that. I don't think it does, but you'd have to check with the state to be sure. Okay, next question. What is the statute of limitations for an estate or trust for a deceased person? A claim has been submitted to the HOA board for estate or trust from 2019. I'm not really sure what you mean by this. So is it the statute of limitations to get the estate to pay for a debt that's owed by somebody that's a deceased person? I don't know. So I think that may be what you're saying. So we have 6 years to sue any owner for an unpaid debt. I see a claim has been submitted to the HOA board for the estate or trust from 2019. I'm not sure what that means. I'm sorry. This is a good example of I want to help you, but I don't understand your question. So maybe circle back on our first Fridays and clarify. Okay, question 15. We are a very small HOA whose only responsibility is to manage the water well system and periodically grade our dirt roads. We are abiding by the public meeting notification requirements. Are we also required to follow Robert's Rules of Order at our meetings? We have a member of the board that insists that they be followed to a T. You're not required to follow Robert's Rules of Order unless your association documents require it in the face of the document. So it says like all board meetings must be conducted pursuant to Robert's Rules of Order. I'm really not in favor of following Robert's Rules to a T because this is like a 13-volume, book that has all kinds of parliamentary requirements, and I'm not even a parliamentarian, right? What I suggest you use Robert's Rules of Orders for is, on one of our cheat sheets, I think it's our board meeting cheat sheet, we give you suggestions on how to comply with Robert's Rules of Order to help you run your meetings more efficiently. So what I would say is you could take a couple points from Robert's Rules of Order, and remember, it's a 13-volume book, so like very few things, easy ones, like only talk about, one thing at a time, right? And the chair recognizes who is talking. And you can use that effectively if everybody's shouting and screaming over each other. The chair creates order and says, you are allowed to talk, and then backs out, and then another person's allowed to talk. So, there are some good points to it to help you manage meetings if you have kind of a dysfunctional meeting environment, but it's not something that I would recommend that you follow to a T. And if it is in your documents, I would amend that out. Okay, question number 16. What downfalls should an association look at before borrowing over $1 million or long-term debt? Whenever association is looking at taking out a loan, there's a number of different factors that come into play. So, number one, I'd probably be working with your association's attorney, right? And make sure that you have the legal authority to do this under your documents. You should be carefully evaluating whether taking out a loan is the best, thing to do for your community. Some associations finance big projects through, partial loans, and then they fund it through a special assessment or increasing the assessment rate. Some associations take the full loan out and pay it over time. It really just depends. I think what I would do is just that this should be discussed with your attorney and make sure that you have the legal right to do this, and that you've thought through the financial implications, such as interest, and that you understand if you default on the loan that typically the collateral is the incoming assessments, the future assessments. But a lot of associations have, been getting loans in the 27 years I've been practicing. Fewer now because interest rates have been so high, but they're going down. So maybe we'll start to get these questions again. But I wouldn't say that the downfalls would probably be the interest, and you have to, repay it over time, and you have to explain to the membership why this is necessary. But as long as you have a good reason for handling it this way, I'm not opposed to it. Just make sure you get legal advice so that you do it correctly. Okay, question 17. We live in a zero lot line community. There have been disputes about who owns the easements and how to access an easement to maintain a party wall. Should the property manager and board members understand these matters to serve as a resource if property disputes arise? So yes, these are complicated issues. I have seen a couple of these in the last quarter of 2023, and I had to reread the provisions like multiple times just to make sure I fully understood what the intent of the drafter of the CC&Rs was trying to do. So zero lot line communities with access easements, to maintain a wall, that may be on somebody else's property. These are complicated issues. So yes, the board member or the property manager should, do their best to understand it. But the reality of the situation is maybe you need to bring in your trusted advisor, attorney, to help go over the issue with the board so that everybody understands it and is on the same page, because these are complicated issues. Okay, question number 18. Does Arizona law require that a chairperson for a committee need to be a board member? So yes, there's one committee that it is required that a board member chair it, and that is the architectural committee, and that is right in state law. If you want to take a look at our cheat sheet on committees, or, I think we also have one on the architectural committee specifically, go to our website at mulcahylawfirm.com and look at our cheat sheet on it. Question 19, we are 56 unit COA in Sun City. Is it a law that our landscaper has to have a ROC license, or is it just good practice? If a law, can you give me the state number? So we have a great blog on this topic called It's Worth It, Hired, Licensed, and Bonded Contractor. We're going to be sharing it with you on Zoom and also on Facebook Live. You can also find it on our website at mulcahylawfirm.com. So A.R.S. 32-1151 sets forth Arizona's contractor licensing requirements. A couple of things to think about. If the job amounts to less than $1,000, it could be that there is an exception. But for landscapers, it's my understanding that they have to have a license with the register of contractors if they're doing any sort of irrigation work. So what I would suggest to you is that you, first ask your landscaper, do you have a license, ROC license, registered contractor's license? If they don't, you may want to call the register of contractors and explain specifically what the landscaper is doing for your community, and determine whether or not they need to have a license. Now, anytime you have a landscaper coming on your property, they really should be insured and bonded. And 99% of the time they are doing irrigation work if they're a landscaper, so they should be licensed too with registered contractors. Okay, question number 20. As opposed to many other states, Arizona Condominium Act statutes are lacking or absent in articulating member interests and fiduciary duties owed to members. It appears boards then defer to the Nonprofit Corporation Act to determine fiduciary duty obligations. This does not protect owners' investment interests. Question: how might an association go about creating an amendment to their CC&Rs and bylaws so as to articulate some form of beneficial interests or fiduciary relationship? Honestly, I don't think that's necessary. It's right in the Nonprofit Corporation Act, the fiduciary duty that a director owes to the corporation. It's the duty of care, duty of confidentiality, and the duty to avoid self-dealing or conflicts of interest. Almost every association in Arizona is a nonprofit corporation, so this law applies to you. If you want to go above and beyond and put it in your CC&Rs or bylaws, you certainly can do that by amending your documents. However, it's not something that I have seen anybody do in Arizona. And, we've worked with thousands of associations. Okay, question 21. Is there an Arizona statutory definition of townhouse versus condominium? And does it matter if the HOA homeowners own the real property, but are referenced as condos in the bylaws and rules and regulations? So this is a good question. This is kind of unusual in that Arizona does not legally recognize townhomes. So in Arizona, you are either a condominium or you are a planned community. Townhomes are kind of like it's like three circles, right? Townhomes sometimes can be in the middle, and some of them may be condos and some of them may be planned communities. It really all depends on the definition section in the townhomes. Like if the townhome association owns the common areas, typically they're going to be a planned community. If it's a townhome and the individual owners in the townhome own a percentage interest in the common areas, it's going to be considered a condominium. So your question is, does it matter if the HOA homeowners own the real property? That means typically you're going to be a condominium. And then you're saying, but are referenced as condos in the bylaws and rules and regulations. I mean, that's legally proper, because if the homeowners own a percentage interest in the common areas, it's technically going to be considered a condominium. So if you have any questions on this, reach out to our firm. We can look at your documents and tell you specifically what your association is. Question number 22, can the association legally limit the number of group homes within the association's boundaries? So we have a great cheat sheet on this. It's called Federal Laws for Community Associations. The Fair Housing Act is a federal law that applies to condominiums and planned communities. So can the association legally limit the number? My answer to that would be no. The city, town, municipality, or county may have limitations based on how many can be in a certain geographic area. So you may want to check in with them to determine if they have any for the association that you're asking about. In my experience, it's usually there's plenty allocated under the local governments. So we've never successfully been able to limit the number of group homes within an association's boundaries. In my experience, that's going to be really difficult to do, but check with your city, town, municipality, or county to see what their restrictions are. All of these group homes do need to be licensed through, the city, town, municipality, or county. So they will have the information at their fingertips, but associations cannot do that. Okay, next question, number 23. And I'm just going down to the end. It looks like we have 33 questions, so we're getting close to the end. Are there any programs in Arizona that could help the lower income association with major repairs through low interest loans or grants? Yes, absolutely. So whatever city that you live in, you should be checking with them because they do grants every year. Now, the cities are typically operating on budgets that will start July 1st. So, you're halfway through the year right now, more than halfway through the year. Check in with the neighborhood services department of whatever city that you live in. And, they have grants in place. You can apply for one. I'm not aware of any low interest loans, but I am aware of grants that the cities provide. It's not 100%, but they will pay a portion of the grant, sometimes up to 50% for certain projects. Question number 24. Can an HOA require an owner to seek architectural approval before installing a charging station in their own garage and provide proof the electrical service is able to support it? I'm not entirely sure on that. I don't know if your garage has like a door or if you're a townhome or what's the situation here. I probably need to find out more information. Or if you share walls with somebody else. I mean, I don't think that it's unreasonable. And probably should be pretty easy to do because, you know, however you're installing it, you're probably using, somebody who's qualified to do this, or maybe it's just a machine that you plug in the wall. As I really don't know the logistics of how it works. So I'm not sure if they can require it. I'd have to look at your documents specifically, but I'm not opposed to it because we certainly don't want to have a fire, right? But if it's not something that falls under, the rights that they would have under your documents, you may be able to challenge it. But I'm kind of sitting here thinking, why? You don't want to fire either. So, it seems to me like it's not that unreasonable of a request. Okay, number 25, we live in a condominium complex. Each unit has its own garage. How can we monitor to ensure another one on this, to ensure an owner does not install an electric car charger in the garage without the HOA's knowledge? It may be unsafe and overload the building's electrical capacity. It's kind of funny. Sometimes I used to write a column for the Arizona Republic many, many years ago, it's like 20 years ago now. And occasionally when I was writing the column for the Arizona Republic, it was called HOA Q&A. The same day I would get a question from owners in the association and the board, and I would be hearing, different facts. So it was always challenging on how I responded to it so that I didn't get a bunch of screaming people yelling to the paper that I didn't have my facts right. So it's interesting that the question right before here has somebody asking, do we have to get architectural approval? And then the very next question is, it's a condo. Okay, so that was one of the things I said when I answered the other question. I don't know enough about your association's documents, but I do think in a condo complex that this is something that the association could be involved in because I'm not sure that the garage is considered part of the unit, and we want to make sure that these things are a safety issue. So I'd have to see the documents again to give a formal opinion on this, but it doesn't seem unreasonable. But to give a formal opinion, I think I would need to see the documents. Okay, question 26. Do you recommend an HOA requiring a homeowner to purchase a host liquor liability policy if they are hosting an event in a common area where alcohol will be provided by the homeowner? So great question. So somebody's having a party on your common areas. I would check with your insurance agent to see what they recommend. I know my association where I live, that we do have to have a policy. Typically, it's just, our actual homeowner insurance policy, for the home, is something that we can just provide, and it's sufficient. A copy of the policy being in place, your insurance agent may say, yes, they do need a special 1-day permit. I mean, it just depends. I mean, if you're having, like some ladies over for bridge and you're going to have 1 bottle of wine and 8 people are drinking it, I mean, I'm not sure that that's something that you're going to need to get the insurance, right? But if you're having, you're bringing in the Miller beer trucks and you're having a block party and it's going to be a little nutty, then that may be something where we want to have that policy in place. So check with your insurance company, get more information about what the event is going to be, and then make a decision. Number 27, the latest move against the open meeting law is to have the board approve authorization for the president or management accounting to $3,000 to $5,000 to cover unknown expenses like projects, maintenance, travel, and education. Is such an arrangement really legal? So I think what's happening here is the board pre-approves authorization for the management company or a board member to spend money in the event something should happen. I'm not opposed to this because things do come up in the summertime, especially for example, pool pump breaks, and it's hard to get a quorum of the board to make a decision. So maybe in advance, they say any directors or the management company is entitled to spend up to $5,000 for an emergency. I'm fine with that. Education type things, maybe there's classes that come up where the manager or the board members want to take a class, and it's last minute and there's a cost for it. I'm fine with that. I mean, just as long as it's in the minutes of the meeting and the number is reasonable, I'm totally fine with that. Question 28, regarding community perimeter walls. One thing I want to make clear is that if they do cover an unknown expense, I think it would probably be a good idea just to notify the board at the next board meeting. Okay, these unknown expenses were, we spent money on these last month, so that there's a paper trail, so that there's not just like, blank check. And, we spent this over these months, and ask for approval after the fact of that as well. Okay, next question, number 28. Let's see. It's like we have about 7 more questions. Regarding community perimeter walls, one got blown down in a storm. HOA board has not checked with legal on repair, and homeowners insurance says it is the HOA responsibility. Yet the board refuses to see if the HOA is responsible. Who can the homeowner go to? Okay, this is a serious issue. So if you have a perimeter wall that was blown down in a storm, that needs to be, addressed immediately by your board. Also, if the wall was so structurally unsound that it was blown down, I think the structural integrity of the entire wall should be looked at to make sure that there's not other issues. So, the board really does need to get their legal counsel involved, and they need to get moving on this. They also, maybe need to check to see if the insurance might cover it, because sometimes like an act of God like this, where the wall gets blown down, might be covered by the insurance. And the longer we wait, the more likely it is that it's not going to be covered. So I guess what I would do, if the board, isn't doing anything, or you're claiming the board isn't doing anything, what could you do? You could write an email to the association's attorney asking them to look into it. You could write an email to the insurance company for the association asking them to get involved or to contact the board to look at it. Before you do that, though, make sure that you attend a board meeting or you write a letter and make sure that the board receives it, so that you're not going around the board. You want to give them ample opportunity to look into it. And if they're blowing you off, then you take those other routes. Okay, number 29. Do you have an example or template for a social media policy? I don't, but I do have a board code of conduct. I'm not sure if I have anything in there on that. I think I do, but what I would do is take a look at our cheat sheet on Board of Directors Code of Conduct. We have sample language in there, and you can find that on our webpage at mulcahylawfirm.com. Really, all you need to say is that board members should not be moderating any social media, pages. So board members should not be the moderator on anything. That is inappropriate for a board member to be moderating a social media webpage or whatever, Facebook or something like that, while they're serving on the board. Because it could be perceived that this is now the board's platform. Also, board members should not be commenting on social media. I think you could just put those 2 things in my Board of Directors Code of Conduct and you'd be fine. Okay, question number 30. Can the board hire a full-time management without consulting and asking the HOA? So, good question. Probably yes, they can, but you'd have to look at your documents. It is a board decision in my experience. And usually the board does make that decision without asking the HOA for their approval. The board should have good communication and be transparent with the homeowners. If they're doing this, this should be discussed at a board meeting. The reasons and the rationale for going to full-time management should be conveyed, and they should be seeking input before they do it. So short answer would be I'd have to see your association's documents, but yes, generally speaking, they have the right to do that, but they should also be communicating well why they're doing it and the costs and how it's going to be beneficial. Okay, we are down to our last 4 questions. Let's see if any more got added. No, last 4 questions. As a board president, how do I change landscapers and or a management company? My HOA has approximately 2,200 homes. Okay, so in terms of changing landscapers and a management company, as board president, you're leader of your board. You just need to start documenting what the problems are, right? And, you need to get a majority of your board to agree with you. And so you can talk about performance during executive sessions where it's just the board, and, you don't have to invite the management company. Obviously, you don't have to invite the landscaper. If you have an executive meeting like this, it has to be noticed 48 hours in advance. If you don't want to have an executive meeting because you don't want to warn the management company that, hey, we're thinking about firing you, the board president can go and talk to other board members, less than a quorum, about your concerns. And then you can, talk about it at a board meeting. You can talk about it in an executive session. I would recommend that you reach out to our firm or your lawyer, because you want to look at the contracts for both of these entities to determine how to terminate the contract with the landscaper or the management company. And you want to have a plan in place. So you're going to want to, be interviewing new management companies, new landscapers. There's a whole process for this. We can help you with it. We have a sample RFP, your request for proposal, you can send out for the management company. But you definitely want to reach out to our firm or your lawyer and talk about it. We have a great cheat sheet on selecting a management company. So after you get rid of the management company, finding a new one, that we have a good cheat sheet on our website on that. But thought and planning needs to go into this, and also some strategy, because sometimes issues come up when you fire the management company and you want to pre-think it. And you also want to pick a company that's going to be good. That's going to be a good fit so that you don't have issues going forward. So reach out to our firm. We're happy to help you with it. We've been through that process many times, and I think we can give you some good tips. Last 3 questions. Any advice for a transition team from builder developer to owner, or a new board when little or no assistance is received from the association or builders board? You bet I have advice for you. You definitely need to check out our cheat sheet on transition from developer to homeowner control as a starting point. We're sharing that with you on Zoom and also on Facebook Live right now. You can also find it on our website at mulcahylawfirm.com. You may want to reach out to our firm, and maybe I can give you, like a free 5-minute call just to kind of go over what's going on and point you in the right direction. Honestly, while you're the transition committee, you really don't have a lot of rights other than your rights as a homeowner. But there are some things that you should be aware of that are problems that typically come up during a transition time, and want to make sure that you have those on your radar, and that you do not sign any sort of a acceptance or a release of the developer. That's the most important thing for the transition team. You should have separate legal counsel, not the same legal counsel that the builder uses for the association. So whoever's the attorney for the association right now, I mean, I'm sorry to say this, but the developer is controlling the board. So you got to be really careful. That's not your attorney as the transition team. You need to get a separate attorney to help advise you through this process. Okay, question 33, last 2 questions. We have a homeowner who gave the board a bill for electricity that they are claiming their mother let the board use for a sprinkler timer. Is there a statute of limitations on how long the estate has to make this claim? Okay. I think this is a clarification for the earlier question that I didn't understand. There's a 6-year statute of limitations on breach of contract. So, I guess what I would say is, number 1, was there anything in writing on this? Number 2, the mother's deceased. So it's kind of questionable as to, this claim is being made after the mother passed away. Is the sprinkler timer really on, that lot's electric bill? If it is, you really should be switching that, because it's not really appropriate to have, doing this reimbursement. You should just have everything be nice and clean. Everything should be in the association's name. So I'd say reach out to your association attorney, my law firm, to talk about this. I mean, I'm kind of leaning towards, I don't think that this is something that I would pay as the board, but I'd have to hear more. Like if there was something in writing, you could go 6 years back, based upon breach of contract. But I'm leaning towards thinking this, that this is not something that I would advise the board to pay, but I have to hear more. Okay, question 34. This is going back to the new legislation bill. Let's see if this is actually the last question. Oh boy, this bill is a long one. I'm not sure I'm going to be able to answer this quickly. So let's see. You're asking me, get this House Bill 2084. You're talking about proposes to strike the ability to give notice of meetings via pamphleting, via delivery to each unit, and requires in-person notice or delivery to registered email or address. Okay, so it sounds like they're changing the method, or this proposed law is potentially changing the method to deliver information regarding the association to registered email or address. I guess your question is, wouldn't this change or inhibit the members' right to call a meeting to conduct business, including recalling a board, as members do not have access to registered contact information, and rental units do not allow for ease of in-person contact to assure notice of 100% members. Okay, so it looks like this particular section talks about written notice. So this is a type of notice that would be this new law. It's proposed. This is not the actual law in Arizona. This is a proposed law that says that, you know, meetings of the membership can be called, you know, a certain way, and then the notice of the meetings of the membership can be done by the following means. You can give it in person. That's been what the law has always been. It's one way. By mail to the physical address of the member's lot, which is the way it is right now, or the alternate mailing address designated in writing by the member, or by email. This is the addition to the email address designated in writing by the member. You know, I guess from my perspective, I'm okay with this bill. I really am. It gives us another method to notify the member. The member can pick which way they want to be notified. I mean, it's very rare that people are getting notice of meetings in person unless your association is really small, like 10 or less homes. I'm okay with it. And I don't think it does impede, because I think if, you know, if there's an email address that's designated in writing by the member, I think that's now a book and record of the association, and it can't be considered a personal, you know, record. And we'll have to give you that if you want to notify the membership of something yourself, if you want to call a special meeting. You know, also remember that if you are, you know, says you're calling a board, really the board sends out the notice anyways. So you're not going to have, you know, it's not, the issue that you're raising is really not going to matter, because the board is going to be the one that provides notice. And if they'll provide notice the way that the owners request under this new law, this goes into effect. So good question. I like that you're thinking. I'm okay with that. If it does pass, actually it would make everybody's life a lot easier, because sometimes we have difficulty finding people. And email, let's face it, is it wouldn't be the only way to communicate with them, but it would be a way to another way to get a hold of them and notify them of things going on in the association, including special meetings of the membership. Okay, so we had a great class today. I'm really happy to announce today that we had over 155 attendees today on Zoom, and many more on Facebook. Like, that's got to be a record for this year and last year. So happy that we had such a great turnout today. I think it was a good topic because we covered a lot of different things, and we kind of did some planning for 2024. So thank you so much to everybody for being here today. I'd also like to thank the different cities that we partner with to teach these virtual HOA Condominium Academy classes. Again, I'd like to thank Avondale, Chandler, Glendale, Goodyear, Peoria, Mesa, Phoenix, Scottsdale, Surprise, and Tempe for allowing me the ability to partner with your cities and the neighborhood services departments in your cities to provide free information to homeowners, board members, and managers, so that everybody is aware of what's going on in our industry and has a place that they can go to for free to ask questions and have them answered. Just some closing remarks. Our next First Friday event, don't forget that, is going to also be February 2nd, first Friday of the month, starts at 9 a.m. And lastly, please consider leaving a Google review for these classes or for our law firm if you've worked with us directly before. We are sharing a link in the chat on how to leave a review. We are always happy to get feedback from our valued customers and for those who are attending these classes so that we can continue to improve our service. Also, in order to keep these classes going, it's important that I provide the different cities that we work with evidence that these classes are valuable and that it's a resource that you like, because every city evaluates whether or not these classes are something they want to continue over time. And having the direct evidence through a Google review that you like these classes and you would like to continue seeing them in 2024 helps me because I provide that feedback to the cities. So please consider doing that. We would really appreciate it. And again, the Google review link is right there on the information that's on Zoom or on Facebook Live. So thanks again, everybody. I hope you have a great 2024 for your associations. Work on those goals this month for your associations. And I look forward to seeing you at any upcoming classes in person in January or virtually in February. So thanks for being here today and have a great day. Take care.